All right. Welcome, everyone, to the latest episode of Scrubbing the Skies, the webinar series of the Institute for Responsible Carbon Removal at American University. As always, I am your host, Will Burns, the co-director of the Institute, and I'd like to thank everyone for coming to the webinar today. So, this is something I said a couple days ago at a webinar we did that's equally applicable here, right? We all know it's going to take a village to raise the CDR sector. We all know that we face significant headwinds, and every effort must be made to facilitate, to create efficiencies and synergies to ensure that the industry stands up and is at a level that it can propel itself to requisite scaling in the future. One of the important components of this, maybe one of the less sexy but incredibly important components of this, is efficiency in the contracting process, right? Which is important for buyers, suppliers, the lawyers that help design these agreements, and intermediaries. And efforts to simplify contracting, reduce friction in terms of times and cost, create consistency that creates certainty and confidence is critical. And fortunately, we have some really good minds thinking about how to do that. And today, we're bringing in two people who have been integral in working on a new process for contracting called OSCAR, the Open Standard Carbon Removal Purchase Agreement. And Peter Mayer is a partner at Stairs, Dillenbeck, Finley, and Mayer. And Jason Grillo is a principal at Earthlight Enterprises. And they've been an integral part of development of this system, along with a large number of other industry practitioners. And so today we're going to talk about the OSCAR process, how to use it, where it fits within the wider ecosystem in terms of developing a market for durable carbon removal. So, as always the case, we'll start with an initial intervention by our guests. I will then follow that with a couple of seating questions, and then we'll move to audience questions. I would encourage you to begin to populate the Q&A box as soon as you have questions so I can gauge how much time I should reserve at the end for those questions. And with that, I will turn over the podium to Peter.
Thank you, Will. Thanks a lot for having us, Jason and me. Yes, so Oscar, the idea for Oscar was born out of a closed door session with CDR buyers that one of our co-founders, Glenn Morley, held. And one of the sort of major issues that came out of that discussion was the lack of standardization in agreements. Uncertainty, especially among new buyers or potential buyers that are sort of teetering on the fence and are wondering if they should go into CDR or not, complaining about the lack and expressing concern about the lack of standardization of contracts. And we took that idea away, bounced it around in our heads a few months, and developed an agreement template for CDR offtakes. In this process, we spoke to many stakeholders in the industry, and what we developed is sort of a baseline where basically anybody buying or selling CDR can start from. It is a baseline template. It's openly available to anybody. It may still need adjustments based on the particular specifics and details of the transaction, but it is a very good starting point, we think. Oscar is it's a volunteer pro bono project. and it's just sort of a contribution to the industry in an effort to help the industry. So it's an open source foundation, right? Everyone has access to it. It's being hosted on the website of CDR.fyi. There will be a new version. It was published during COP in November. There will an updated version will be published shortly. Just some minor changes, editorial glitches, and a few minor changes, but it will be an updated version available shortly. There will also be a German law version being published. So the first version was on a New York law. We'll now publish one on a German law as well, and we're going to talk during this webinar a bit more about it. There will also be rolled out across additional jurisdictions. But the main purpose is sort of to make this process, contracting process, more efficient by arriving at a standard that is widely acknowledged.
And building on that, Peter, so as Peter mentioned, the idea is to look at friction points. We notice that oftentimes the contracting process is very fragmented. People might adapt contracts from other industries, not CDR, to the purpose of forging a CDR written agreement. That didn't seem to be the most efficient way of producing a document, leading to months and months and months potentially of back and forth among legal teams. By having OSCARs that, again, free public standard contract, that enables teams to save time and in doing so reduce costs of legal fees. Mind you, this is both on the buyer side, on the seller side, on the intermediary side, and on the financier side, to evaluate the contract for it being a legally defensible contract and creating, as mentioned here, a standard framework to scale carbon removal markets globally. Just to be clear too, the template that I shared in the link in the chat is intended to be really a starting point, and that anybody who downloads that, certainly feel free to look at it, feel free to see what it holds, what it offers for you, and also highly recommend looking at getting an attorney of your own to evaluate. That could be internal, it could be external counsel. Nonetheless, the idea is to have a template that's 80 to 90% of the way there with customizations available. It is not the final word in terms of CDR contracting. And that speaks to some of the open source nature of what we see, that we want to have. We want to learn feedback. We want to learn how people are using it. So yes.
Yeah, absolutely. So it is, in that sense, it can really be also, it can be used as a checklist also. If you're a supplier or a buyer and you have already your own contract and maybe you arrived at this version after a long and painful process, then it will be difficult just to toss it out the window and adjust the new and adopt a new agreement for usage. That's also not our intention. We don't want to. There's no intention sort of to impose it on people or saying this is what you have to do. This is not. That's not what it is. It can also be. You can also use it as an educational tool. You can use it as a checklist, basically, against the contracts you are using, and saying, "Oh, that's a good idea. We didn't think about that." And so it can, in that sense, it can give you comfort also in what you're using, and it is hopefully a contribution to arrive at a stage of market comparability, in the sense that I've negotiated many offtake agreements, and so many of them look just completely different from another, and that causes a lot of friction, right? If you get an offtake agreement, you really never quite know what it's going to look like if it's come from the other side, and that causes a lot of friction. There aren't many lawyers out there that focus on CDR, so for them, it could also be a very helpful tool, right? When I got into CDR, we're all learning in this industry. It's all very nascent. That also applies to the legal industry. And when I got into CDR, I wish there would have been something like that out there as a starting point. There's also a guidebook that's published on the website of CDR.fyi. It gives some additional background on the agreement and the purposes of the clauses.
Yeah, and the purpose of that guidebook is for people who are not as familiar with legal terminology to have a way of relating to the document so that the contract is becomes ultimately more usable. In that light, it's intended, yes, for corporate buyers. It's intended for intermediaries. It's intended for legal teams, for finance teams, and for CDR suppliers. That way, having at least a template in hand or in your pocket when you're approached by a counterparty or you approach a counterparty, that's the way to really feel more empowered in negotiation, as we say here, and also to streamline the time and to make the transaction happen that much more quickly. And who knows, perhaps the counterparty already has a version of Oscar in their in mind for their own purposes as well. That way, it serves as a comparison point, knowing that again, a good amount of the terminology is something that would be common to everybody. Again, as Peter mentioned, we're not trying to impose this on the world. We offer it as a free public resource for people to adapt and adopt as they see fit across all stakeholders.
Right. So, having said that, it is a ready-to-use template. We're using it in our daily practice. There are transactions that are being done using Oscar today with sort of very prominent players in the industry. And like I said at the beginning, obviously you need to make adjustments based on the specifics of the deal, but it is a very good starting point, and you can it's basically a ready to use template. But you should always do that with legal counsel involved. Don't do it on your own. MRV integration is something that's very important for buyers, obviously, in terms of scrutiny for carbon credits. There's strong language for that in the agreement. It provides clear commercial terms regarding pricing and delivery schedules, payment terms. And there is, so with help of the guidebook that goes with it, also some practical insights and guidance available to navigate the CDR landscape.
Right, and we've talked a little bit about the objectives for Oscar to get to that position of easing transactions. Again, in terms of transaction velocity, to reduce time from several months to hopefully just several weeks. Bankability is a very key term that is something that we want Oscar to be able to underpin. And in that light, making CDR transactions more, having them be the basis for equity financing, for debt financing, for project financing. That's the other goal behind Oscar. And yes, we spoke with other attorneys. Yes, we spoke with a variety of stakeholders when developing Oscar to learn about what terms and conditions and what clauses would be able to make the contract more bankable. Also, transparent risk allocation. Again, who bears what risk? What provisions might there be for, say, insurance? What provisions might still fall on the developer? What provisions might fall on the buyer for risk? And one thing that I think Peter touched on as well, but just to underscore, this is method agnostic. Yes, it will work for direct air capture. Yes, it will work for biochar. Yes, it's intended for enhanced rock weathering or marine carbon removal, biomass burial, you name it. It is not specifically for one method of CDR and one method of CDR alone. The idea is that it can be adaptable across any type of operation in the CDR landscape. And in a larger sense, the goal here is to move from very bespoke to turnkey as the industry matures, as startups grow up, as larger check sizes come in. A standard contract, which we've seen in other industries such as electricity, can be a useful framework for making these very, very large scale transactions happen.
I just go to the last slide so that we have more time for questions and Q&A. So how you get started with Oscar? Download it from the website of CDR.fyi, have a look at it, see if you can use it, check it against your own agreements that you're using, right? It is a baseline standard that applies pretty much to all pathways. It's a good starting point across all pathways of CDR. It's mainly designed for durable, but with some adjustments, and an attorney would help you, guiding you what those adjustments would be. It can also be used for NBS. This is the first draft. There may be, we may get to a stage where we say, use this. This is more for DAC. This is more for ERW. This is more for NBS. This is more for an offtake. This is more for a spot. So there may be variations that we're building out over time, but this is a starting point. And also contribute, right? We're looking to people to the extent you can do this, obviously confidentiality requirements and so forth. But to share feedback, right? Was Oscar helpful in your process? Did it help you reduce time? What clauses caused issues? Unlike the Frontier contract that was published some 2 years ago and then sort of left to the market, we see this as a marathon. It was published 2 months ago, and it is sort of for us now a starting point to get it deployed in the market. That's going to be the challenge. And it's not going to work if people don't use it, if people don't contribute. We'll talk during this webinar a little bit more about how we are seeking engagement and what we are trying to do to get engagement back from folks using it. But this is supposed to be a living document that is supposed to be enhanced and developed further as the industry grows.
All right. Okay. Thank you very much, Peter and Jason, for that overview. So we will now move to questions. And as I said, I encourage everybody to populate the Q&A box, and I'll monitor that as I ask some initial questions. So let's start off with one of the things that you talked about at almost the very end, Peter. I think a lot of initiatives in the CDR world and all worlds crash on the rocks of indifference, often in the field, and so the question is how not to have that happen here, right? So one of the things you alluded to was ensuring that the folks that could potentially use this see it, provide feedback, and so forth. So what's your outreach strategy, and what are your suggestions to those that are interested in potentially engaging with you in this context?
Right. So for one, we use CDR.fyi, which is a great platform for that. Everyone has access to it. Everyone knows about it. It's widely available. Their integrity is outstanding as an impartial contributor to this community. We also wanted to be very clear that this is not driven by any kind of industry, any kind of particular buyer group or supplier group. It's neutral. And there is a tool on the website of CDR.fyi where people can leave comments, suggestions, feedback. That's one thing. The other thing what we're doing is that we're talking, actively talking and engaging players in this industry, um, buyers, suppliers, and particularly intermediaries, since they are have sort of the widest exposure to the buy and the sell side. Um, and for instance, I can say we used it for a couple of transactions for Senken that worked pretty well. It's a very smooth process compared to others that I've seen. So that's one thing. And the other thing that we're doing is that we are reaching out to lawyers across various jurisdictions, and getting them involved as well. So I said at the beginning, it's going to be published very soon on the new version, the new updated New York version will be published very soon together with the German law version. English law is in the works. Yesterday, I had a conversation with Herbert Smith in Paris. They're very interested in this. Canada, Switzerland will follow soon. Singapore and Japan is what where we're reaching out to next. So this is sort of, and if there is sort of some kind and understanding in the major jurisdictions among legal practitioners that this is available, we hope that this helps sort of in creating a standard just by adoption across various jurisdictions.
Great. So, as a pseudo lawyer myself, right, I know there's existing templates, right, for contracting that at least in theory can be applied across a lot of industries. And so my question is, what's wrong with adapting those existing templates? What kind of specific market problems or negotiation bottlenecks have you seen that drive the need for a new standard durable CDR template of this nature?
Right. I mean, there's some many people go back sort of to a PPA, right? Power purchase
Hmm.
agreement. That is sort of something. Let's do that, and then we adjust that a little bit. It's a very
Yeah.
different market, right? You everyone needs power. Uh, you know how to produce how to build a power plant, and you know exactly how to sell your electricity. Um, this is a different kettle of fish here in the sense that technology may not be as advanced, so the project still needs to be built. There may be delays because of technology issues and whatnot, for instance. Um, you're trying to sell something for which there isn't really a market, right? Who needs carbon credits? Is that right? And corporations don't necessarily have a budget with it. There's a difficulty in selling this internally for many companies, right? They go to their CFO and they get the answer, why should we buy credits that we don't need with a budget we don't have? That there is, and on top of that, buyers sometimes think, oh, am I not just buying a lot of issues here myself? What if this doesn't work out, right? I don't want to see our company being on page one of The Guardian, being told that we bought some, you know, false credits. So this is a very, and these are all, so right, there are reputational issues. There are delivery delays, maybe generation delays of carbon credits, which are all very specific to this kind of industry, I think, and that requires sort of a particular approach. Um, I mean, But you're right. I did the same thing, right? My first entry into CDR was like, let's look at a PPA,
Right.
and then try to adjust that, right?
Mhm.
But it is an effort adjusting it. You can just see we know what the issues are, so let's build something for that rather than take an agreement that was made for something else and try to adjust it. We can genuinely do a CDR offtake agreement for this industry. We don't need to borrow it from somewhere else and amend it.
Yeah. Now, I know some. Oh, did you have something to say too, Jason?
Yeah, I just want to say on the other hand of the spectrum, there's this notion that we've heard anecdotally stories of some startups just designing their own,
Right.
2 or 3 page agreement.
Yeah.
And what we wanted to do here is craft something that uh, is robust enough, and will stand the test in a court of law. And this, again, on one end, it's adapting a very well-known structure of a PPA. On the other hand, is well, we'll just make it up from scratch. So this is that kind of happy medium in between, which is tailor-made already based on legal input.
Right. Have you seen people generate some of these from AI, and what's been the result?
Well, we've heard stories of people starting to generate it from AI, and I would not recommend. Frankly, I would not recommend that. Having coached startups, for quite a bit, that's might seem like a. I will say that might seem like a feasible shortcut in the near term, but if it ever goes to court, I shudder to think about what the results of that might look like.
Yeah, that's really sort of a route one shouldn't take in transactions of this kind of some complexity. You shouldn't have your contracts built by AI. It's not only, one thing is if there's ever some kind of a dispute or a lawsuit, it also doesn't look good in a funding round, right? Let's say you want to get a VC involved and they do due diligence and then they look at these 2 or 3 page agreements and say, well, these are your major, these are the big contracts that you have. It just doesn't look good, right? So don't do that. Um, that's not a good approach. You can use AI if you know exactly what you're looking for, right? You can ask
Hmm.
AI a specific question and say,
Right.
hey, I am here in a CDR contract. I'm looking at this clause. Can you help me word this a little bit in this or that direction? So if you know exactly what kind of questions to ask in the context, AI can be helpful. But just say, we have a ERW project and draft me a CDR offtake agreement. That's not gonna be good.
Okay. All right. So you used the term kettle of fish before, and so I want to look at something in here that I think is a kettle of fish, right? And that's Article 6, right? That talks about our old friend MRV, right? And um, I don't want to say it blithely refers to this, right? But it conclusively refers to utilizing, quote, prudent industry practices for MRV. Uh, is that going to get people where they need to be, given how momentous a role MRV plays in this process and how complex it is for various different kinds of CDR approaches, right? Is it a little too generic and is it a little too vague? What do we do with that?
Um, you really sort of get to the crux of one of the major issues here. Um, the challenge is MRV will evolve over time,
Hmm.
right? So we know MRV will be better probably in 2 years from now than it is today. Um, so, and how do we deal with that in a contract situation? I think we need to have some kind of flexibility, knowing that things will evolve. That doesn't necessarily bad. That doesn't mean we should wait until we get to that point. That will constantly evolve, right? We can only do as good as we are able to do it today.
Hmm.
That's what we're trying to express with sort of best industry practices, which we also have in other areas of, right? So if you define negligence, it can only be a standard as is sort of seen as state of the art today. Um,
Right.
right? If you have the same
But,
incident in 2 years from now, you cannot apply that, right?
right. But maybe the difference between negligence and best industry practices for MRV is negligence has standards that have been developed for hundreds and hundreds of years, right? And best industry practices in this context, right, is a lot more limited in terms of that experience, right?
Absolutely. I mean, maybe it's sort of not an ideal example,
Hmm.
but because it is fairly new MRV in this context, I wouldn't know how sort of better to describe it,
Hmm.
other than say, well, what's been widely adopted now, and
Hmm.
what is being seen as best practice, that's what you need to apply. Whatever that may be, that will
Hmm.
then sort of depend on, the facts and circumstances of the particular situation. Um, and it is a bit vague, but that vagueness also helps for purposes of this agreement, to make it widely usable, right? So if someone
Hmm.
wanted to say in a particular transaction, saying, I want to have more specifics, for example, taking out more criteria of an MRV protocol, saying you need to exactly comply with section A, B, and C in this protocol. And that's what we understand as best practices for purposes of this agreement. That's fine, right? But for this template, I think the best we can do is sort of using this term, and using the definition that goes along with it, which contains some criteria as to what that is supposed to mean in practice.
Great. All right, thanks for that. Okay, let's look at some of the questions that are coming in from the audience. First one, bit of a challenge, I guess. It says the concept of quote high permanence seems flawed as it eliminates many ocean CDR technologies.
Well,
Jason,
again,
maybe
I
that's
would
one,
say
maybe
that,
that's one
we
for
just,
you.
yeah, yeah, yeah. I mean, I would say we designed the contract with any ocean solution in mind. Again, any other method of carbon removal that is applicable. It can be, 1,000-year duration of removal, as many wish to see. It can be a couple hundred years. I would imagine there's even could be even provisions for, soil organic carbon sequestration. So depending on what the definition of high permanence is, um, I would say Oscar can manage that. I don't know if this, Phil, it's good to see you again. I don't know if this was about the market in general or about the Oscar contract, but I would say Oscar should be able to handle, say, ocean upwelling solutions, as just as well as, provided that they have a MRV that ensures that the carbon has been indeed removed from the atmosphere.
Yeah, yeah, Phil, if you had a follow-up for that, feel free to put it in the Q&A, but I'll move to the next question, which I think you've answered. Could it be applied for nature-based removals, not biochar? Intelligent biochar would arise to that in one form or another. But right, the answer is correct. Yes, right?
The answer is yes. Yeah. It was mainly drafted sort of with durable solutions in mind, but it can be used for NBS. Just make a few, got to get your head around it a little bit, sort of about permanence, delivery schedule. So, you need to grace periods maybe for generation shortfalls, delivery shortfalls. So it's some flexibility there that are nature-based specific. Um, but as a template, again, as a template and starting point, it works.
Yeah.
Yeah. I would also add that we've already fielded some inquiries from nature-based solution project developers. That's already prompted us to have some discussions within our Oscar volunteer team about how we would could adapt Oscar, or how Oscar could be adaptable to those solutions. So your question, Yevgen, is something that others have inquired about already. So the wheels are turning at this point.
Yeah. I was curious in that context, does it include an option or do you contemplate an option in the future for horizontal and vertical stacking, perhaps of nature-based options or sequential contracts that start off with nature-based credits and commit ultimately to moving to durable credits to ensure long-term durability for company commitments, for example?
Um, gr Very good, very good question. This, I would say that, I mean, Oscar doesn't sort of, there's no real mechanism in Oscar to sort of reflect that now, right? But with a bright mind, you can take Oscar and build it out that way.
Hmm.
You don't need to sort of, it's not in here. That's not what I'm looking for. Let's lose something else. You don't need to do that. You can take Oscar, and I think it can be developed in any of these directions. You just need to know how to do it. You need to have a lawyer who knows how to do that and who can help you with that. But I would say, so we didn't have that scenario in mind, obviously, right? That's very specific, and it's a great concept, and I like that kind of scenario. But it's so specific that we didn't have it. Obviously, we didn't have it in mind for this kind of template. But thinking about it, it's certainly something that could be done.
Great. Okay, next question. Big tech buyers like Microsoft and Google are trying to make room for smaller CDR buyers to join on the projects they may provide initial financing for. How would Oscar be adapted to enable newer and smaller buyers to participate in that kind of marketplace?
Jason, you I mean,
Yeah. I would say that it, the template that we have can be used by any scale of buyer. It can be used by a buyer who wants to buy hundreds of thousands of tons of credits, or an intermediary who wants to create a deal for that volume. Smaller buyers also have provisions. It also has provisions for smaller buyers. It should be adaptable to enable buyers who are on the sideline to enter the playing field. I mean, that's the whole idea behind Oscar, right? That we cut down the legal back and forth and save money and time so that these smaller scale buyers can participate initially and then move on to potentially larger purposes, larger purchases, I should say. One thing to note too is that just because it's other templates that are out there, we found that they're a little bit like very, very buyer centric, and that's fine. Except that if a financier, for instance, would like to see something that's a little bit more balanced so that the power is not entirely with the buyer. For small buyers, again, if they intend to catalyze the market, it makes for a more bankable contract that would enable those larger purchases to come in later.
And just to add on that a little bit, Oscar was designed sort of from a buyer's perspective,
Hmm.
right? So we because since it came out of this buyer's session, we said if we want the market to grow, we need to provide the tools to those buyers that have not entered the market yet to do so. So we looked at it from a buyer-friendly way. Having said that, it is still sort of, we did that in a balanced way. So unlike the frontier contract, for instance, which is very buyer-friendly,
Hmm.
this one is more balanced. It takes into account that CDR companies are very often startup companies with limited resources. It does not make sense to burden them with obligations and liabilities they won't be able to fulfill. So we wanted to build something that gives buyers credits, keeping in mind the capabilities of suppliers. But going back to that question, that's exactly what Oscar is actually trying to do, helping smaller buyers. That's sort of the primary. That's how we started out, sort of as the primary group of people for whom this could be interesting. But it can also, it also works for suppliers or intermediaries.
Yeah, and that stems from the uh, feedback from the market that Glenn Morley on our team had, that I've had, just learning from buyers that they want to, but contracting is a friction point. So it's a hurdle, and we want to unlock that. We want to get them again off the sideline and into the playing field, so to speak. So especially for smaller buyers who might not want to buy as much at first, this enables that, and hopefully scales to larger purchases in the future.
Great. All right, next question. Oscar's built to help CDR contracts withstand legal scrutiny. At this point, how much legal scrutiny has been brought to bear on such contracts in the United States and the European Union?
Um, Oscar is being used, right, in the market. There are transactions that are being executed using this template. So it's not just a theoretical exercise. The question really asks as to how many of these contracts have been, or how much litigation experience and offtake agreements there is. I don't know. I'm not aware of any actually.
Hmm.
I don't think there has been. I don't think there has been much litigation, if any. I'm not aware of it.
Is there likely to be more as the European Union, for example, develops the standards and theoretically the United States at some point in the future could again also, but in Europe currently, given both the direct standards they're developing for CDR, but also increasing standards for things like green claims, right? Is it likely that scrutiny will increase in this context?
Um, Potentially. I mean, we've seen litigation in this context mainly with respect to public disclosures,
Yep.
false reporting requirements, right? Where false reporting, where company says we're carbon neutral, and what does this actually mean? Then the consumer asks and sues the company and potentially wins.
Right.
In the context of an an offtake agreement, so what we see in the market is that there are delivery shortfalls, right? So
Hmm.
we're now seeing that contracts that were signed 1, 2, 3 years ago, that suppliers have issues delivering.
Hmm.
Does it make sense to sue them? in most cases, commercially, probably not, right? If they
Right.
don't have credits, if they're on credit, what are you going to sue them for? It makes no sense, right? So that's one thing why there hasn't been a lot of litigation, I would think. Another thing is also for publicity reasons, right? Why would a buyer sort of expose himself to that audience, saying, well, we bought credits, it didn't deliver. And so litigation, I think, in this context hasn't really been an issue. It's more like, the company makes false disclosures or misleading disclosures in its SEC filings about its green policy or its activities. These sorts of things I think they will probably, I expect an increase in those kinds of litigation also in Europe potentially, and that can have, sort of um, let's say, that can have an impact as to how the market evolves.
Yeah.
Mhm.
I would offer too that as the market becomes starts to scale, as we see more transactions, but more importantly, as we see more complex transactions, the ability to make those negotiations simpler, to streamline it in some way. I don't know that's going to become a commoditized market, but I would say that Oscar's way of making the provisions of the delivery, the shortfall, and all the risk bearing more standardized, so that it heads off the propensity for people to litigate simply based on the contract purchase and delivery terms.
Hmm. Yeah, I'm surprised that there's I understand your point, Peter, about if they can't supply, what are you going to get, right? But I'm surprised there's not more efforts to create liability and demand, for example, insurance, right? There's a nascent insurance market for carbon removal now. Is that something that's not contemplated in your standard contracts, and why not?
So if a buyer wanted to, sort of say, I want to get I want to get carbon insurance, they can do that. I just wouldn't say, and there's nothing that prevents them from doing so.
Or
Um,
demanding that the supplier do,
but
right?
right.
Yeah.
Um, but it's not in the agreement because I don't think we are there yet. I wouldn't say
Hmm.
this is standard, right? So it,
Hmm.
it would introduce. We've listened also in this process, so we've spoken to many stakeholders and sort of gathered what is sort of widely accepted.
Hmm.
And then, and then we had an agreement that was sort of much longer, and more extensive and more detailed than the one that we published. And then we got the feedback and saying, "Oh my God, this is like, this is overly complicated and and you got to shorten it, to make this more digestible for people."
Hmm.
And I believe we even had like sort of an optional clause or some kind of comment about, carbon insurance in there,
Hmm.
which you then took out again. Maybe that's something we could sort of pick up in the guidebook. Actually, that's a good idea. But yeah, I mean, the market will more mature when sort of the three cornerstones, I think, are right. You need to have good contracts, you need to have insurance, and you need to have money, financing.
Right.
Right? With law firms, banks, and insurance companies involved in an industry, you're typically on a good track.
Yeah. Adding to that, I would also offer, if there are provisions that you as a community would like to see in Oscar, please let us know. That's why we are hosting it on CDR.fyi, so that we can listen to what you want to see and update it going forward.
Yeah, that's a
So I
that's a
highly
good
encourage,
that's a good point.
yeah, yeah,
That's a
yeah.
good
I
point.
mean, look, this is Oscar right now. It's for Oscar version 1.0.
Yeah.
and that's great. But again, we see this. I think Peter mentioned earlier. It's a living document, right? So as it gets used by different parties, as it gets to be used even more for transactions and larger transactions, or again, the permutation will that you mentioned, you asked Peter about, can be used for this or that. That's something that we would love to hear more about. How are you using it? How are you adapting it? What clauses are you adding in? What clauses are you eliminating? Are you just using it vanilla as is? Again, that's specifically the type of commentary we would love, love, love to hear. And our Oscar team is, again, we're waiting with bated breath to hear what you all think about it.
Yeah, yeah, I think that's really good. I mean, I think when we talk about people in the CDR industry collaborating, cooperating, there's obviously times that's not realistic because there's competition, right? In a lot of contexts, right? But this is something that I think everybody can benefit from, right?
Right.
Reducing the friction of contracting is just in everybody's best interest, right?
Yeah,
So,
and just adding to it, look, we're all volunteers on the Oscar team, right? We're
yeah,
not, Oscar is not an entity. It's not a not-for-profit. It's not a for-profit.
yeah,
We're doing this as a free resource for the community to use. So the CDR community, the carbon removal community to use. And yes, that's something that we have the community interest in mind, and we saw this as a problem in the market infrastructure. There's a gap in the market infrastructure rather, and that's what we wanted to fill with Oscar.
great. All right. Another question regarding quote unquote prudent industry practice. I've never analyzed the issue, but my starting assumption would be that language like this in a long-term agreement would impose a contractual duty that evolves along with industry over time. Have you analyzed that or any thoughts on that topic?
Um, yes, it is. It is sort of an open definition, and what this means in practice would evolve over time, right? So you gotta be sort of up to date with standards, MRV protocols, and permits, regulations that are applicable to this particular project. You basically have this also in other contexts where an operator needs to apply with sort of the state of the art conditions as they exist at the time, and that is an evolving and enhancing standard.
Great. Another question. Was Oscar developed to be adaptable also for biodiversity credits in addition to CDR? I understand this is poorly developed compared to CDR. Yeah, hard to believe, but it is true, I think, in my experience. But any
Yeah,
thoughts?
yeah. I mean, we were mostly thinking about durable carbon removal,
Hmm.
and I certainly appreciate the heightened interest in biodiversity credits we've seen over the last, say, 2 or 3 years. I'll defer to Peter's expertise about how it could potentially be adapted to that. But uh, to your question, we didn't have biodiversity in mind, at least for version 1.0. Again, to my previous point, if you see a pathway for that, love to hear more.
Yeah. Anything to add on that, Peter?
No, I mean we had CDR we had CDR in mind, but there are similarities, right?
Hmm.
There are clearly similarities. Um, and I
Right
mean
there.
now from
Could
the
even be
top of,
mixed contracts in some
yeah,
sort, right? For being
exactly,
delivered, right?
exactly,
Or
right?
hybrids. Hmm.
Yeah.
Yeah. So, okay. So let me ask you a bit as we come to the end about some some practical advice that you could provide to those that may want to utilize Oscar in the future. If a supplier or a buyer is going to use Oscar for the first time, or at least engage with it, um, what are the two or three clauses that you think they should look at first?
Right. I mean, and a CDR offtake agreement, want to boil it down to its essential, to its essentials, it's basically a purchase agreement, right? So,
Hmm.
so the main clauses are, how is it ensured that I get title to the credits, right? So
Hmm.
transfer of the credits, how does that happen? When is the point in time that they belong to me and I can retire them and claim the environmental benefits associated with that? That is
Right.
sort of very important for a buyer.
Yeah.
And for a supplier, it's very important, when do I get paid? So, right? So payment schedules, um, and then obviously remedies in that kind of connection between delivery and payment, right? What happens if there is a delay in delivery of the credits? What are
Right.
the remedies? These are the things that are sort of really at the core of any CDR offtake agreement, right? Delivery, payment, remedies if something sort of goes sideways in that relationship.
Great. Another question. So who in your mind are the ideal early adopters and fast followers of this?
Oh, um, ideal adopters. So I think we've shifted a little bit our initial idea. So initially we thought this is be great for buyers, which it is. But I think in terms of market exposure and getting this more out in the market, I think it would be ideal to be adopted by intermediaries,
Hmm.
since they have the greatest exposure,
Right.
um, and they can,
Say a bit more about who fits into that category and how you
right.
define it
So
in this context.
right. So companies that build carbon credit portfolios for corporate buyers.
Hmm.
That would be the ideal entity for to adopt Oscar and to use it.
Hmm.
Yeah. And
And are
building on
you
that
getting,
specifically,
oh, go ahead, Jason.
so I was going to say, we're talking brokerages, we're talking marketplaces, we're talking consultancies, those types of third parties who are not product developers supplying, nor are they the end user of the transaction. They sit in the middle.
Right.
Those specific types of companies are what we have in mind when we talk intermediary.
Hmm. Have you been getting some good engagement with that sector? That's an
Um,
interesting sector, right?
right,
In the CDR world.
right. So the challenge about that is that we've had good conversations. We've had intermediaries who are using it.
Hmm.
The challenge that there is a little bit is that um, they already have contracts,
Yeah.
right? So, and then, oh, here's something new. Should we? It actually works fine the way we're doing it, or so they think, right?
Right.
And very often there is, however, a lack of understanding as to sort of the risks that are embedded in the contracts they're using, which very often is something that they developed 2 or 3 years ago, and they just keep on using it. And I think in many, I don't want to mention names, but I think in many cases, sort of there are underlying risks sleeping there, that some intermediaries are not aware of.
Hmm.
Um, and what we're trying to do is not to say, hey, listen, you have to use Oscar. Um, we're just trying to sort of get them engaged in saying, take a look, use it as a checklist, right?
Hmm.
This is a free tool. Just compare it as to what you have and make that assessment if you think you are on the right track.
Yeah.
Yeah, I think that's
And
good
yeah,
advice.
and it's still a new market out there, so
Ah,
very much so. Even though, again, it's been several years since the IPCC report came out talking about carbon removal. So I would offer that the landscape is still ripe for adapting and adopting Oscar and adapting it to purposes. And by the way, even if you see the Oscar template and you don't want to use it, that's also a piece of feedback we would love to hear as well.
that's great. Well, that is a good place for us to stop. We're at the top of the clock, and I would like to once again thank our guests for joining us, Peter Mayer and Jason Grillo. Thanks to our audience, as usual, for your thoughtful questions. We will be back with a Scrubbing the Skies episode in February, so look for us via our mailing list, the CDR forum on LinkedIn, and so forth. And thanks, everyone, and we will see you then. Bye now.